Hi, Rick Martin here with Martin IP Law Group, back with another installment of Frequently Asked Fridays, where we answer your questions about patents, trademarks, copyrights, and trade secrets. Today we're going to talk about IP in general, and the question we're going to answer today is, who can I safely talk to about my intellectual property? And that question really depends on a couple of different factors. First off, you can always talk to your attorney about your intellectual property, specifically an intellectual property attorney like myself, who's trained in identifying intellectual property and advising you on how to protect it. Attorneys, when you're disclosing this to your attorney, there's an obligation for the attorney, an ethical obligation to maintain confidentiality of anything that a client relays to an attorney. So anything that you tell your IP attorney about your intellectual property is subject to that attorney-client privilege and confidentiality, and it's safe to talk to your attorney about that. As far as talking to anyone else about your IP, from a patent perspective, probably a good idea to do either one of two things. As far as have them sign a non-disclosure agreement before you disclose your IP to them and tell them what your IP is, or have at least a provisional patent application on file so that you have a filing date with the patent office and you are patent pending before you disclose your idea to anyone else. There are a number of things that can go wrong and oftentimes do go wrong if you disclose this to someone without one of those two things in place. So we hope that's been helpful to you. Again, if you have questions about disclosure of your IP to anyone, need a non-disclosure agreement, need a provisional patent application, we're here to help and we'll be glad to sit down and talk with you. Thanks. Have a great weekend.